Welcome to the East Texas Community Health HIPAA Privacy Training. The purpose of this training is to give you a brief overview of HIPAA and to also define how East Texas Community Health Services has implemented the HIPAA required directives into our daily operations. The HIPAA privacy and security rules dictate that all who may come in contact with protected health information go through a training on HIPAA policy and that there be documentation to prove that the training has been completed. This program will train you in the basic HIPAA rules regarding the use, transmission, security, and privacy of healthcare data. In August 1996, Congress enacted the Health Insurance Portability and Accountability Act, also known as HIPAA. The primary purposes of HIPAA are to protect people from losing their health insurance if they change jobs or have pre-existing health conditions, to reduce the cost and administrative burdens of healthcare by creating standard electronic formats for many administrative transactions that are currently carried out on paper, and to develop standards and requirements to protect the privacy and security of health information. It is these security standards and privacy standards that this program will discuss in more detail.
One of the most important things to keep in mind about HIPAA is the rule of thumb: if you don't know, ask. Ignorance of the law is no excuse, so if you're not sure, ask your supervisor or the compliance officer. East Texas Community Health's compliance officer is Jan Henson, who can be reached by either her email listed here or by phone at extension 1109. Also, the network has a web-based form that allows you to file an anonymous report in the event that you wish to do so. Finally, remember that you cannot be retaliated against for reporting a concern in good faith. One of the key terms you will hear about most is PHI, or Protected Health Information. PHI is any information, whether oral or recorded, in any form or medium that is created or received by a healthcare provider, health plan, public health authority, employer, life insurer, school or university, or healthcare clearinghouse, and relates to the past, present, or future physical or mental health or condition of an individual, the provision of health care to an individual, or the past, present, or future payment for the provision of health care to an individual. Simply put, PHI is any information that may be used to determine a patient's identity. PHI is created anytime any two or more of the following data elements are combined together, such as names, all geographic subdivisions smaller than a state, all dates except for year, for dates directly related to an individual's birth date, appointment date, date of death, etc., or a handful of other unique identifying numbers, characteristics, codes, or combination that allows for the identification of an individual. Another term that is commonly used in HIPAA is TPO, or Treatment, Payment, and Operations. TPO covers activities related to a patient's treatment, such as office visits, consultations, and reports. Payment services, such as those that would be through Medicaid, Medicare, or insurance companies. And operations, which generally govern day-to-day activities of treating a patient. The HIPAA privacy rule permits disclosure of PHI only for TPO or when regulatory exception applies, for example, public health reporting. By law, the HIPAA privacy rule applies only to covered entities, health plans, healthcare clearinghouses, and certain healthcare providers. However, most healthcare providers and health plans do not carry out all of their healthcare activities and functions by themselves. Instead, they often use the services of a variety of other persons or businesses. The privacy rule allows covered providers and health plans to disclose protected health information to these business associates. If the providers or plans obtain satisfactory assurances that the business associate will use the information only for purposes for which it was engaged by the covered entity, will safeguard the information from misuse, and will help the covered entity comply with some of the covered entity's duties under the privacy rule. Covered entities may also disclose protected health information to an entity in its role as a business associate only to help the covered entity carry out its healthcare functions, not for the business associate's independent use or purposes, except as needed for the proper management and administration of the business associate. The minimum necessary standard, a key protection of the HIPAA privacy rule, is derived from confidentiality codes and practices in common use today. It is based on sound current practice that protected health information should not be used or disclosed when it is not necessary to satisfy a particular purpose or carry out a function. The privacy rule generally requires covered entities to take reasonable steps to limit the use of or disclosure of and request for PHI to the minimum necessary to accomplish the intended purpose. The minimum necessary standard does not apply to requests for treatment purposes, disclosures to the patient when the information requested applies to the patient, or disclosures as required by law or to comply with HIPAA administrative and security purposes. The main difference between use of PHI and disclosure of PHI is the relation to the entity using the information. Any PHI utilized internally by the entity is considered use, and any PHI that is given or transmitted to external entities is considered disclosure. An authorization is required by the privacy rule for uses and disclosures of protected health information not otherwise allowed by the rule. Where the privacy rule requires patient authorization, voluntary consent is not sufficient to permit a use or disclosure of protected health information unless it also satisfies the requirement of a valid authorization. An authorization is a detailed document that gives covered entities permission to use the PHI for specific purposes, which are generally other than treatment, payment, or healthcare operations, or to disclose protected health information to a third party specified by the individual. The privacy rule gives individuals the right to revoke at any time an authorization they have given. The revocation must be in writing and is not effective until the covered entity receives it. No authorization is required to be obtained from the patient in cases where the patient is requesting their PHI. When disclosing PHI for treatment, payment, or healthcare operations such as referrals, insurance processing, and to business associates. In certain cases, such as when the patient is not alone in an exam room, hospital directories, or disclosures to clergy, the patient must be given an opportunity to opt out of the disclosure of PHI. For research, fundraising, and marketing activities, patients must give written authorization for use of PHI. Most customary healthcare communications and practices play an important or even essential role in ensuring that individuals receive prompt and effective healthcare. Due to the nature of these communications and practices, as well as the various environments in which individuals receive healthcare or other services from covered entities, the potential exists for an individual's health information to be disclosed incidentally. For example, a clinic visitor may overhear a provider's confidential conversation with another provider or a patient, or may glimpse a patient's information on a sign-in sheet or nurse's station whiteboard. The HIPAA privacy rule is not intended to impede these customary and essential communications and practices, and thus does not require that all risk of incidental use or disclosure be eliminated to satisfy its standards. Rather, the privacy rule permits certain incidental uses and disclosures of protected health information to occur when the covered entity has placed reasonable safeguards and minimum necessary policies and procedures to protect an individual's privacy. Some reasonable safeguards that can be used include speaking in soft tones, being aware of the environment when discussing PHI, and using the minimum necessary PHI. According to the security rule, it is permissible to use the Internet to transmit PHI as long as an acceptable method of encryption is used to protect confidentiality, and appropriate authentication procedures are followed to ensure correct identification of the sender and receiver. Although faxes are transmitted over telephone lines, they are not considered to be covered transactions by the security rule, and however, they are permitted by internal ETC HSI policy. For email, we are now able to send encrypted email to both internal email addresses, those ending in @tac.org or @etchc.com, as well as external email addresses using TAC's Ironport server. To encrypt emails using the Ironport server, simply add "Send Secure" in all caps in the subject line, and the mail server will take care of the rest. Minimum necessary is the concept of increased confidentiality, and employees may only access or disclose a patient's PHI when this access is part of the employee's job duties. It is never acceptable for an employee to look at PHI just out of curiosity, even if no harm is intended. It also makes no difference if the information relates to a close friend or family member or a high-profile person. All information is entitled to the same protection and must be kept private. If an employee accesses or discloses PHI without a patient's written authorization, or without job-related reason for doing so, the employee violates ETCHSI policy and HIPAA and may be subject to disciplinary action, including and up to termination. The security rule portion of HIPAA also requires administrative, physical, and technical safeguards be in place to prevent the improper use or disclosure of PHI. These safeguards primarily deal with security and transmission of data that contains PHI. Personal authentication based on password security is put in place to ensure the data is sent to the intended recipient and received by the intended party, and therefore it is vital that users not share passwords or logins. Also, users should make sure to log out or lock their workstations when they are going to be away from their desk for an extended period of time. Concerned that HIPAA and high-tech did not provide enough safeguards to protect health information, the Texas legislature passed House Bill 300 in 2011. This law, containing even more stringent regulation than in the federal scheme, went into effect on September 1, 2012. HB 300 defines a covered entity as any individual, business, or organization that engages in the practice of assembling, collecting, analyzing, storing, or transmitting PHI, comes into the possession of PHI, obtains or stores PHI, or is an employee, agent, or contractor of a person described above. Under the new Texas law, covered entities must provide ongoing customizing training for their employees regarding both federal and state law related to the protection of PHI. Each new employee must complete training within 60 days after his or her hire date, and the training must be repeated at least once every 2 years. Notably, under HIPAA, training is only required with a reasonable amount of time after hiring and when there are any material changes in privacy policies. Under both HIPAA and HB 300, cover entities must maintain records of every employee's training attendance. Beginning in September 2012, covered entities must provide patients with electronic copies of their electronic health records within 15 business days of the patient's written request. Under HIPAA, records must be provided within 30 days of a request. Additionally, the new Texas law requires that the Texas Attorney General establish a website that explains patients' privacy rights under Texas and federal law. Also contained in HB 300 are provisions that prohibit the sale of PHI and require notice to patients regarding the electronic disclosure of PHI. Covered entities that wrongfully disclose a patient's PHI will face increased civil penalties under HB 300, in addition to any penalties for violating federal laws. The new Texas law allows for penalties ranging from $5,000 to $1.5 million per year. To determine the penalty amount, HB 300 lists 5 factors a court may consider. 1. The seriousness of the violation. 2. The entity's compliance history. 3. The risks of harm to the patient. 4. The amount necessary to deter future violations. And 5. Efforts to correct the violation.